So we have some important news in the battle to end the NFA's restrictions on suppressors. This all comes after the Trump DOJ recently changed their position on suppressors and agreed that suppressors are in fact protected arms. But the Trump DOJ continues to argue that the NFA and its suppressor restrictions can be upheld, but now this is likely heading to the Supreme Court. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also, you can click on the notification bell and turn on all notifications because that helps to ensure that YouTube will send you these videos once I release them. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was recently ruled on by the Fifth Circuit Court of Appeals. Now, the stakes in this case just got even higher because of what the Fifth Circuit has ordered. This case is called U.S. versus Peterson, and it deals with the constitutionality of the NFA as it applies to suppressors. Mr. Peterson challenged his conviction of violating the NFA based on his theory that the NFA and its suppressor restrictions do in fact violate the Second Amendment. On first review of this case, the Fifth Circuit 3-judge panel found that suppressors are not arms at all, and because of that, they do not trigger two-way protections. However, the Fifth Circuit recently issued a new ruling in this case, and the 3-judge panel once again ruled that even though suppressors may be protected arms, the NFA's restrictions do not violate the Second Amendment. They argue that under Bruin, the NFA operates as a shall issue permit scheme and therefore is permissible. That, of course, is shocking and very concerning, and it has broad-reaching implications for other two-way issues going forward. Now, in response to that new ruling by the Fifth Circuit, Mr. Peterson was seeking for the Fifth Circuit en banc panel to review this case. The Trump DOJ submitted their response to that petition, arguing that the en banc panel should reject review of this case because, once again, they believe the NFA's restrictions on suppressors are in fact unconstitutional and they operate as a shall issue permit. This, of course, is not good, and we continue to see a very large trend from the Trump DOJ where they are arguing in favor of the NFA. The Fifth Circuit recently ultimately decided to not only deny en banc panel review in this case, but also they decided to issue a mandate in this case, allowing that decision by the 3-judge panel to be final. Mr. Peterson and his counsel filed an unopposed motion to stay that mandate because they told the court, the Fifth Circuit, that they would be going to the Supreme Court to seek a review of this issue. However, the Fifth Circuit just denied that stay, and this is not simply just a denial by the Fifth Circuit, it also has some big implications for the individual here because he has been released on bond. He has been released based on this conviction, and while this case is going forward and while the appeal is going forward, he has been released. But with the Fifth Circuit denial of that stay, that potentially left him open to having to go back and report back to prison. And this happened even though he notified the Fifth Circuit that he was going to seek an active cert petition to the Supreme Court, and he wanted to hold this while the appeal was going on so he did not have to report back to prison. Again, that was brought up to the Fifth Circuit as a reason why they should grant the stay of the mandate, but apparently the Fifth Circuit did not care. But luckily for Mr. Peterson, once he went to the lowest court, the district court, they issued an order allowing him to remain out on bond pending the resolution of his Supreme Court writ of cert. Now, for those not aware, in this case, essentially back in 2022, both federal and state law enforcement officers executed warrants at Mr. Peterson's home in Louisiana. There was a federal task force of ATF agents and 50 law enforcement officers that executed search warrants at his home and his home-based FFL in Louisiana. Now, they claimed that the search warrant and there were some issues based on some improper record keeping, 4473s, straw purchases, and then they also claimed that some of the items sold at that home-based FFL at that location were arriving at crime scenes. Now, Mr. Peterson and his counsel, oppose that. They say that is not true, but essentially that is essentially what they were executing the search warrant for. But really, this whole issue arises out of the fact that when searching his home, I believe in his safe in his bedroom, they found a solvent trap that was not registered as a suppressor under the NFA. And based on that one item, he was charged with violating the NFA. In response to that charge, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. Now, on review, the court there, the lowest court, denied his motion to dismiss the indictment, and that led Mr. Peterson to appeal to the Fifth Circuit for the first time. On original review, the Fifth Circuit sided with the Biden ATF and the Biden DOJ, and the Fifth Circuit found that suppressors are not a necessary accoutrement of a firearm, and it is not required to make the gun useful or functional. Mr. Peterson and his counsel at that time filed for a rehearing en banc in the Fifth Circuit, but like I mentioned, that petition was pulled once the Trump DOJ got control of this case. They changed some of their position on suppressors, said that they are in fact arms, and that led this case to be re-litigated and re-decided by the three-judge panel. Well, even after the re-review by the three-judge panel, they still upheld the NFA's restrictions in that new ruling. The Fifth Circuit still ruled that the NFA can regulate suppressors since the process operates in their eyes as a shall issue permit, which they believe is permissible under Bruin. Now, under Bruin's dicta issued by Justice Kavanaugh, he stated that CCW schemes and shall issue permit schemes may be generally permissible if they apply objective criteria like background checks, fingerprinting, and fees. But here what happened is the Fifth Circuit twisted Bruin and that CCW permit ruling and the dicta issued by Kavanaugh to justify the NFA's registration and taxation scheme. That is why this ruling is so concerning. In essence, the Fifth Circuit's holding now stands for the proposition that any permit system or any scheme like this restricting to a right may be generally permissible as long as it operates objectively according to a court. However, that ruling is now heading up for Supreme Court review. Originally, Mr. Peterson and his counsel were seeking en banc panel review in the Fifth Circuit, but that was quickly denied. The Fifth Circuit also decided to issue the mandate in this case, allowing that ruling against Mr. Peterson to go into effect. Now, like I mentioned, because of that, Mr. Peterson and his counsel asked for the Fifth Circuit to stay the mandate because they would be seeking Supreme Court review. The stay would prevent the injury happening to Mr. Peterson while this case was still in active litigation and was going to the Supreme Court. But unfortunately, like I mentioned, the Fifth Circuit en banc panel decided to deny that stay, even though it was unopposed and even though the Trump DOJ agreed that the stay could be issued while this goes to the Supreme Court. This concern about the impact it would have to Mr. Peterson was raised to the Fifth Circuit, but they still denied it. Mr. Peterson, in response, went to the lowest court, the District Court, and also asked for his bond and release to be extended, pending the resolution of his Supreme Court petition. And luckily for him, the District Court granted that motion. In a recent order, they stated that it is hereby ordered that George Peterson shall remain on bond under the same conditions and with the same stipulations as originally set by the court, pending resolution of his petition for writ of cert to the United States Supreme Court. They stated that if appropriate, this court will set a new self-surrender date following the proceedings at the Supreme Court. So that is good news for Mr. Peterson and his counsel, and they now have until March, I believe, to file for Supreme Court cert and to get the Supreme Court to review this case. This is a critical case, not just because of the NFA and the suppressor question that's being raised and the whole constitutional questions surrounding the Second Amendment, but also this is high stakes for the individual here in this case. Inaction by the courts and inaction by the Supreme Court may lead Mr. Peterson to face some serious prison time. So that is what's going on right now in this critical suppressor challenge. We will now see how this plays out once Mr. Peterson and his counsel seek Supreme Court review. And ultimately, we will see what the Supreme Court decides to do with this NFA issue and the suppressor challenge. It is an uphill battle because the Supreme Court recently has denied a lot of NFA challenges. Right now, they have some rifle ban questions in front of them, some magazine ban questions in front of them. It's yet to be seen if they're going to take one of those cases. But one of the interesting things with that is if they do potentially take a rifle ban or a magazine ban case and address, what are protected arms, that could also impact this case. So hopefully for Mr. Peterson, there is some positive news moving forward out of the Supreme Court. But currently, that is where this case stands. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of 2A content and it should share it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.